Members of the panel, my name is William Reisdorf, and I'm an attorney. I've been a family law attorney for 30 years, and you have in front of you a packet with highlighting on it and a cream-colored card on it. That's me. There's three things I want to talk to you about today. I'm going to go to the second one first, because there seems to have been a lot of time spent on the issue of domestic violence. And I want to suggest to you that the advocates of this bill have, and I believe, and entertain, a zero-tolerance attitude about domestic violence. There is not one advocate of this joint parenting bill that I am aware of that has anything but that particular attitude. However, I suggest in my literature that the passage of HB4564 will force judges to put mothers and children into danger is, in my humble opinion, a myth. And I want to suggest something to you. Number one, so that you know the situation today. If a person feels that they are the victim of domestic violence, under existing Michigan law, they can file a petition for domestic violence, a PPO. Like anywhere in the state of Michigan, you can go as a domestic violence victim to a circuit court, and for free you can be helped through a petition process. My experience in 30 years has been that typically if a person is granted a domestic violence PPO, all contact is cut off with the perpetrator. Let me suggest that again. All contact with the alleged perpetrator of domestic violence is cut off. So there's a firewall that already exists that was passed in Michigan law through efforts of the domestic violence people many years ago, and it has worked well. Number two, the notion that under this bill a domestic abuser will sit down with a victim and enforce the victim to negotiate with them is false. There's a court rule that says that cannot happen. There's a court rule that says you cannot mediate in a situation in which there is a PPO that has been filed or there is a juvenile matter involving domestic violence. It cannot happen. So there's a firewall that exists already. Thirdly, and there have been people that have suggested this, and I find this incredible. I've been all over the state. I've litigated in much of the Lower Peninsula. Under existing law and under the future law, I would find it hard to believe that a judge would find any hesitation to render and adjudicate a perpetrator of domestic violence, an alcoholic, a drug abuser, anything but unfit. The term unfit, you will say, is a too broad term. I suggest to you that that's a relative term. In this business of family law, our statutes are full of broad terms. It's not too long before we attach particular meanings to them. But the notion that a father will manipulate the system and then not exercise his parenting time is also not neglected in the new legislation because of the word unwilling. This is, in my opinion, remarkable in its simple wisdom. A parent must be found to be unwilling, unfit, or unable to provide for his child. The only thing that's different, ladies and gentlemen, is the burden. The burden shifts. However, that does not prevent a victim of domestic violence from getting a PPO instantly. I represent several fathers whose mothers have made legitimate claims for domestic violence, and I don't have a statistic, but it seems like more than not, petitioners who petition for personal protection orders are successful. And once that happens, in my experience, 90% of the personal protection orders result in a no contact provision. Okay, so they're protections that are already built into the system. And so to focus on one small gamut of the population, one small area, albeit significant, the area of drug abusers, the area of the alcoholics, certainly that's a significant portion of the population to be a significant issue. But this dovetails into my point number one. The majority of parents that go before the court, and I suggest to you the typical practitioner of law in Michigan, the majority of parents that go to court are not people that have to get personal protection orders, are not people that whose husbands are drunken drivers, are not people who are drug abusers. They are average people. This law says that average people should start on an equal plane because there is no other evidence of otherwise. What this legislation will do is reduce the contention. My brother from the other side of the aisle, so to speak, Mr. Weechman, said we have a system in which the backbiting, the difficulty has been taken out of the law. Things go very well. That's baloney. Things do not go very well. The cases that are litigated before the court are litigated on a system that promotes contest at all times. If two parents go in front of the court, and by the way, ladies and gentlemen, that's only in 15% of the cases. 85% of the cases are settled in the state of Michigan, typically because one parent, typically a father, is told he can do no better. The 15% that are litigated are ones where the child is taken from both parents and given back to the one parent who can show by 1% or more that that parent is a better parent. The literature that I've provided to you says that that's baloney. You don't have to be a perfect parent to be an involved parent. This literature suggests that the benefit to having children involved with both parents in their lives is so pressing an issue that it can result in our children being more effective in school, more effective in the community, less likely to become involved with criminal actions. And so, in order to prevent this litigation and this contention over which parent may go take the child to the dentist more than the other parent, there have been people that have come to you, notably Helen Brown several years ago, who said, this is absurd. We have to stop this absurd contest that continues here and litigate over which parent is 1% better a parent than the other. I suggest to you that there is built into the system plenty of safeguards with respect to the domestic violence issue. They are already there. I know of no judge, in my experience, would hesitate to find an abuser unfit. Does it require mother to bring that issue up? Yes, it does. It does require mother to bring that issue up. And well, it should be brought up. Now, I close with this particular suggestion. There's been talk of there being a financial advantage to the father demanding more time because it will reduce his child support. You should be advised of the fact that come October or November 1st of this year, I can't remember which, the procedure in which a father is given a discount for having more of time with his children has been watered down substantially because of this very tiff, because of this very contention that exists out in the hall where mother says, you just want more time so that you can get a reduction in your child support. Those rules have been watered down, and I think quite fairly, because it's going to stop the argument, and it's going to be a more equalized, less drastic discount. And so that is less an issue. I suggest to you that you have to take a look at the whole picture. You have to take a look at the literature that indicates there's a reason why that 80% of the people that are in our jails, that 60% of the poor, unfortunate females who are the victims of abuse and rape are females who come from a one-parent family. There's a reason for that. The literature keeps telling us of that, and we have to wake up and take notice of it.